Warning: mature content. The following stream contains content that may not be suitable for all audiences, including mature themes, strong language, and potentially sensitive material. Viewer discretion is advised.
Hey, J-Bo Nation! Shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester, the court DJ. It's time to dive into the case. To the case.
What's up? This is live. Hi, this is live. We're live. We're here for the afternoon edition of the Young Thug trial. Thanks for being here. While we're here, I was just checking to see if the Sarah Boon hearing went forward, and it sure did. And I could show you what. I don't have the video. I guess if someone covered it, will be coming out later, which I don't have yet. But I do have this, which I just found. Let me see if I can zoom in. All right, so this is not AIJ. This is real J. Status held. The court addressed several of the defendant's motions and set deadlines as it relates to the exhibits and witness lists. The court will prepare specific order with all deadline dates, as what was stated on the record, including the costs for JACS. The court provided the defendant in open court copy of an email dated 7/24/24 from Gina M. Giovanni, Captain Security Operations, and a copy of today's order setting hearing. Court witnesses sworn and testified: Christian Lake. The court advised Investigator Billy Lane, representative from Prison Break Investigations, to release thumb drive to Orange County Jail. Also released 2 boxes of discovery back to the court in open court. Trial remains as previously set. All right. So I don't know if anyone, I'll keep an eye out to see if anyone actually, if it was live streamed, but that's the update. Let me put this over here. Thanks for being here, everybody. Botrix hasn't woken up yet because that's the old thing. Ooh, looks like we're prompt. We already have some movement. Hey, Irene, official, Mia, Kristen, Nona, Joe, Sarah, Katie. Thanks for being here. Christy, Kimby, Taryn, Katie, Dizzy. Botrix finally woke up. Actually, that didn't take too long. Hello, Botrix. Did Joe say goodbye? Your latex spouse, hey. Annie, hey. Oh, guy, that reminds me. Just real quick. I'm going to pause this real quick. On break, I'm watching the steeplechase. Is that what it's called? Steeplechase? And is there any event more in the Olympics that reeks of someone being stoned and being like, all right, dude, how about we have the guys like a retired runner, a retired 100-meter athlete, a couple of them. All right, so we're going to have them run around the track. They're stoned, taking hits off a joint. Then they're going to jump over this thing like a hurdle. It's not like a hurdle, though. It's like different than a hurdle, but they're going to jump over it. It's thicker than a hurdle. It's bigger than a hurdle. Then they're going to jump it over like this little pool. It just reeks of being stoned and setting up that. Hey, my Bebop life.
No, he's not.
All right, well, in the meantime, one thing we can do that is not anything of substance that is important is I want everybody to speak into your mic and let's make sure each of them works all not at the same time, one at a time. And if there are any that don't work, I'm going to try to see if we can get a hold of one that does. So can we start with the state?
Yes, Sean.
All right, and I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards you some more.
Good afternoon.
All right. Yeah, you're just going to have to get it closer.
User
to you.
error, I think, on my part.
User error. Okay.
Yeah. Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work?
Your Honor, is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great. Mr. Sharp.
Testing, Your Honor.
Great.
Good job,
And
Sharp.
then who else is left? Misty Williams.
Good afternoon, Your Honor.
All right. Wonderful.
Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross check mics off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the Infinity and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes.
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor. I do believe that there was more that she said that was disclosed other than just the Infinity.
Okay, what else?
Specifically when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. That actually came through more clearly than I think anything else, Your Honor.
Okay, so.
May I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
Hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer.
Okay, it happened.
I
Oh, your
silenced
computer?
It.
Okay.
I silenced it.
Damn it,
All right, thank
Weinstein.
So, Ms. Love.
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that they are alleging took place. And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks, I'm using my words, not hers, and gave to them this information, my understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may. Also, the testimony of Mr. in the off-the-record meeting where Mr. Copeland...
The alleged off-the-record meeting.
The alleged off-the-record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again, and the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that I would submit that Mr.
See, this is the lawyer you want. You want the lawyer who's like, doesn't even know what, he's like unliving. He doesn't even know what that means. This is the man you want as your lawyer.
Mr. Copeland allegedly saying, I can claim all of this, I can take all of this, would also be Brady material.
And Your Honor, again, given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting, that assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too. But a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification, you said I had set parameters as to what is and isn't Brady, and
No.
I haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about. This hearing is about whether Brady material was disclosed. And my position was that what Ms. Hilton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady, but if it did, I can put up a witness about it. I just didn't think that it was necessary unless the court saw it differently than I did.
So I guess what I wanted.
Stop being cowards, prosecution. Call Tom Brady to the stand.
To have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that was between Ms. Bumpus, Mr. Copeland, and Ms. Hilton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
All right.
Your Honor,
Oh,
can
boy.
I make a statement before or while Investigator Long is taking
Yes.
the witness stand? I am specifically objecting to the proffer of Ms. Love, always. But in addition, Ms. Love said that me and other people who represent people, God forbid, accused of these acts, knew already about the ex parte meeting and what occurred and the contents therein, and that is just false. that is just false, that was not testified to by Ms. Bumpkus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well? And that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpkus, that me and other lawyers or people on the defense side knew about what was said at that hearing, and that did not happen.
That's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that? All right. So you said you weren't going to accept a proffer from Miss Love, and that's fine. You said also Miss Long. Do you mean Investigator Long or Miss Hilton, or is there a Miss Long?
Spoke. Miss Love is who I meant, but I think because Investigator Long has taken the stand, my mind may have been been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abate, my ruling with regard to that was that's not even relevant until such point as there might be some other defense motion filed, at which point Ms. Love can call Mr. Abate. So, okay, so call Investigator Long. Thank you.
Mr. Long, come on down.
Antoni. Antonio Long, Antonio. Last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's not going to be testifying as an expert, so let's just, cut to the chase.
Short and sweet, Love,
He's
short
not going
and
to be
sweet.
testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Short and sweet, Pat.
So we don't need to go through all of his background.
Don't waste our time, madam. You
Just,
wasted enough of it.
Good afternoon, Deputy Chief Long. Would you tell the court for the record where it is that you work?
I work for the Fulton County District Attorney's Office.
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we are here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? As
Yes.
And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in line and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Miss Kayla Bumpus, several deputies, and with Kenneth Copeland, and myself and Miss Hilton.
Was I present in chambers at the time you arrived with Miss Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Miss Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Miss Copeland.
Okay. Were you present with Miss Hilton when was Miss Bumpus in the room during the entire time that Miss Hilton was in a room with Mr. Copeland?
Yes.
At any time did Miss Bumpus leave the room and leave Miss Hilton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Miss Bumpus testified?
I was.
Did you hear Miss Bumpus talk about an off-the-record conversation that took place between Miss Bumpus, Miss Hilton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Miss Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there ever a time that you all went off the record at either attorney's request, that is either Miss Bumpus or Miss Hilton's?
From what I recall, there were times we stepped out of the room so that Miss Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Miss Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Miss Bumpus is talking about right before we went back on the record. There was a conversation where Miss Hilton spoke with Miss Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Miss Hilton exited the room so that Miss Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you being you and Miss Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room.
Okay.
Except for Mr. Copeland and the deputies.
Okay. Did Miss Hilton have any contact with Mr. Copeland during the time that Miss Bumpus was not in the room?
No.
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, "I can claim all of this"?
No.
Were you and Miss Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
Yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No.
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hilton, can you tell the court the topics that you discussed? That not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed.
The topic at that time, Ms. Hilton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hilton...
All right, hey, back up.
Back up.
So is it your testimony that there was one brief off-the-record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was...
Tina, thank you so much. Gifted a membership to Nona. Thank you so much, Tina. Always appreciate your support.
Was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone to use the restroom.
Okay.
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to get clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in,
Okay.
and then Ms. Hilton did ask she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in time?
Mr. Copeland was in there.
All right, and so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would
seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so
I mean, seems like this guy is confirming in a little more simple way, or the question is that what Kayla Bumpus said, no?
Your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that, where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statements, or inconsistent statements.
I'm talking about just the off the record now.
Who the hell's phone is
Just
ringing?
off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it.
Someone get me that phone number, please. I will call it and order a pizza.
That phone being the desk phone on the bench for some reason. I don't know why. Okay.
Yeah, it's little Woody.
Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would she would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something, and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So
If only, I wish there was a world where there were people in this room that had some sort of device that they could wear on their clothing that would somehow record the video and audio of what was going on so we would know exactly what happened. If only there was a world where such a thing existed.
the extent of the off the record before the court got back in their conversation was her essentially just saying, what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it, in a sense, was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of the transcript, line.
So what I'm gathering here is they had this conversation on the record, and then she, for some reason, when they came back, decided again off the record to say the same shit. I don't know.
19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge, And Mr. Copeland says that can get me back in jail. And Ms. Hilton says yes. And Ms. Hilton in line 24 of page 50 says, it's not what you're saying, what you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection, lady.
Sustained.
Yeah.
Sustained. Ask a different question.
Yes, Your Honor. During the conversation off the record, did Ms. Hilton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, lady.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hilton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do that.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
Okay. Do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
He didn't use that word. He said he wasn't going to take credit or say he did something he didn't do. Yeah.
Do you recall that those words you just spoke were in response to a question about the murder of Donovan Thomas?
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand and taking credit for something he didn't do.
And broadly, do you recall Ms. Hilton making comments about Donovan Thomas that Mr. Copeland then made any comments about?
Other than if he got on the stand and took credit for something or said he did something that he didn't do and we knew he didn't do. That was the only statement she made, and then he said he wasn't going to get on the stand to do that.
Okay. Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray infinity that the state, about having information about the infinity that the state doesn't know?
He never said anything about an infinity to me or Miss Simone, Miss Hilton.
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to know if you ever endeavored to find out what he may have said to her privately.
No.
And would it
Go ahead.
Would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about the murder of Donovan Thomas, then we would initiate an investigation. And I would assign one of those lieutenants to assist me with looking into that.
Do you have any memory of any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
Your Honor, I'm
Go ahead.
ceding the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any portions of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just the restroom break.
And what about the content of the off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hilton having the conversation about Mr. Copeland getting on the stand and taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
The incident about the infinity, him claiming that I can claim all of this. The part about you coming back the second time, that's what stands out to me right now.
And was my absence from the interactions between Ms. Hilton and Mr. Scratch that. Your Honor, that's all the questions.
All right. Thank you. Anybody
Defense's
from
turn.
the defense side?
They're all
have
going to be up there.
questions for Investigator Long?
Sure, they have questions. Weinstein first, Steele first, Sharp. Who's coming up first?
Miss Love, do you need a cough drop? Because I actually have some if you need one. Okay.
Sharp. Sharp's number one. Well, actually, Sharp's number two.
Okay.
Oh, that was a good one, Jay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off-the-record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off-the-record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay. And that was before what we're deeming the off-the-record conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay, and that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right.
Yeah.
Thank you.
And you indicated that during this off the record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off-the-record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean what she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yes. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this is me paraphrasing, for something that you did, then knowing we know you didn't do it, then she would seek perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay, and that was out of Ms. Hilton's mouth?
Yes.
Okay, so Ms. Hilton specifically, during the off-the-record portion, referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off-the-record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
it was both.
Killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up the Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
yeah, we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
You know Brian Steele's going up there.
How are you, sir?
How you doing, Mr. Steele?
There he is.
Okay, how you doing?
I'm doing fine. Blessed and highly favored.
Can I answer you a couple of questions?
Yes.
What did he just say? He's doing fine. What?
How are you, sir?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and highly favored.
Can I
Did he say blessed and out of favor?
answer you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Oh, I've never heard that before.
Sustained.
At what point were you initially told that you're going to this ex parte meeting?
Objection.
I want to know which part he was there for. The beginning part, he came with Miss Hilton.
Blessed and highly favored? Is that like highly favored by God? Black Baptist Church thing. Ah, thank you, Lexi.
I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you then?
Miss Hilton, I believe. Yeah. Because of course we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort to the center? Say one more time.
Miss Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you, Your Honor.
You're welcome. Anybody else from the defense?
Nothing from Weinstein?
Oh, I have one other question.
Uh-oh.
Go ahead.
Steele's got something else. Blessed and highly favored was said in Murdoch? I missed that.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
No. If I understand you correctly, did no one tell me not to say anything?
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews. While Mr. Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near
Okay.
the end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's correct.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
Oh, come on.
When you spoke about the comment
She must
that
have
Ms.
taken off
Hilton
her.
made
Never mind. There it is again.
about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualify?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything for we charge. But she did mention the fact of I can only speculate. I was use the word the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mm-hmm.
Thank you.
Anything else from the defense?
Please, no. Let this man leave.
All right. Is the transcript before the witness at this point? I don't know where it went to.
Yes, Your Honor.
Okay. Can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41?
Done, Your Honor.
All right. Is it?
Who's this guy?
I'm done, Your Honor.
All right.
What's
Is
that
it
guy
a
saying?
fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay. And does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Give me just a second. Let me look a little past just to make sure.
Sure. Look at the rest of the end off. And I mean, you may or may not be able to, but if you can, let me know. If you can't, let me know that as well.
What is going on? What is going on?
I don't know why you got to do it in front of the kid with the effing. All you got to do is say earmuffs to him. Earmuffs. And you can say fuck, shit, bitch, whatever you want.
Cock, balls.
Okay, I'm just...
Great job, everybody. I feel like I'm taking crazy pills.
Your Honor, I believe. Page 52.
I'm just playing sound effects now because
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone.
who the fuck has that? Do they have a Rule 22? If not, throw them in jail.
Sorry.
Ron, I believe.
It's been 84 years.
It's okay. 13, 14.
Okay.
When we come back in.
I'm finished with this guy.
Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at
The
lines
meatloaf!
9 through 13.
We want
or
it
so.
now!
Is that right? Okay.
The meatloaf!
And then at line 14, the court remarks, Mr. Clopen, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah, because
so it's right before that the off-the-record conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
No, nothing
Yes,
else.
Your Honor, thank you.
Oh, son of a
Deputy Chief
bitch.
Long, on page 40, lines 20 through 25, when the court
How many times do we have to give her an opportunity?
refers
She's had
to
like 10 times already.
comments made
It's enough.
to Mr. Copeland earlier by Ms. Love, did you ever hear those types of comments made by Ms. Hilton?
Let this
Was
man
there any time you
go
are
home.
aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay.
Finally, jeez.
All right. Investigator, thank you. You may step down. Any other evidence, Ms. Love?
No.
Not about, no, Your Honor, not at this time.
All right. Any rebuttal evidence from anybody on the defense side of the room? All right. Anything y'all want to suggest that this actually means?
That's a pretty hilarious question. I like this judge. I don't know. I like her. Anyone want to suggest what this actually means? Is what she said. What this actually means. No one. Don't get up there fast enough. Oh, is that Steele? I think I saw Steele on the camera. Nope, Shart. Shart's going to explain what it means with his laptop. He's got AI lawyer on there. Going to ask you the question.
Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get this site right now. Ford Motor Company versus Young, 322 Georgia Appeals, 348. And that case deals, that case, when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case, the Ford case, indicates to me that Your Honor and the trial court can play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct,
Okay.
or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
No, Shart. I mean, she ain't granting a mistrial based on this. So they just want her to. I mean, what do they want? What do they want?
So I filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed, that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about my client, Mr. Stillwell. But the purpose of it was to try to inform the court, at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case. And that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of an impartial trial judge and also of prosecutorial misconduct. In this case, from my perspective, we've had, with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judges' chambers to have a discussion. And there were at least 2 discussions that took place. I'm assuming that there was a third discussion, which may have strictly involved the grant of immunity.
All right.
But, right.
I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte, anything with regard to getting the order, or was it just the motion being filed? So, right. I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper ex parte. But these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under an exception to begin with, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about, you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that that doesn't put that meeting with just the judge and the witness who has been sworn in, doesn't put the state at a tactical advantage over the defense who's excluded. I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it, and then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule of Professional Responsibility, Rule 4.2, regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards a tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it.
Yeah, let's do it.
In the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
All right. I would prefer that, since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay?
You've got to fight for your right to ex parte. Na-na-na-na.
I've got it somewhere.
Okay, I've got it right here, Your Honor, from Ms. Persfield's email to us.
AIJ here reminding you to hit the like.
If you've got it at hand, go ahead. But if you don't, I've got it now.
Okay. I'm trying to find out exactly, try to figure out where it was. Okay. Paragraph 11.
Go ahead.
I'm sorry.
Paragraph 11.
Yes. And it says, Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated.
Tribunal?
The reason
was a survivor.
I focus on the violation of these rules is because of the Ford case and the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the facts are there under the Wilson case, as well as the State v. Jackson 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a couple of days ago.
About goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation.
Egregious.
The experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the unit
All right.
that deals.
Can I interrupt you for just a minute?
Uh-oh.
So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well, that
pause
you
it
asked,
for now. I have it.
You asked where we are right now, and that's from my perspective. That's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
I understand.
the information about their qualifications is in your motion.
Yes, Your Honor.
All right.
Thank you.
Okay. And if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abadi might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate.
Thank you.
And I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
Brooklyn's here.
Brooklyn, so Brooklyn.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's co-worker and all the parties. It's Ford Motor Company versus Young. And
Jay, newbie to this hearing, can you give a 30 SEC summary? Thanks from Vancouver, Canada.
Hey, Stephanie. Thanks for being here. 30-second summary. This is a case where it was kind of going on. I don't want to say smoothly, but the case came to an abrupt stop with the Young Thug case with their prior judge, because it was found out that the Judge Glanville had ex parte meetings, meaning meetings with the judge, the witness, a witness involved, and the prosecution that the defense was not made aware of. So the defense made many motions to have the case dismissed, which are still pending. The judge, they made a motion to recuse the other judge, Judge Glanville, who was recused. And now they are going over the sum and substance of what went on in those ex parte meetings. If there was stuff that was off the record, which was alleged, that's what's going on today. And as the judge said a little bit before, the judge is trying to figure out, why we're going into all this stuff. The defense now is making their arguments on why this is not just shouldn't be just like a referral to the Bar Association for the prosecutor, but it should be something to do with this trial, whether it's a motion to dismiss or some sort of sanctions in the trial. I'm not sure. The defense right now is arguing why it was a big deal that they had those ex parte meetings. And thank you for being here, Stephanie. Welcome, and thanks for the super chat. I hope that made sense. I don't know.
Georgia Appeal 348. It's in Division 3, 745 Southeast 2D299, 2013 case. And what our second highest court wrote was and I've given a copy actually to this court. And
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states it in the center. And we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love. And you've inherited a case that has a lot of history and a lot of it bad. And I put into my motion, I could go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement. I don't know if you've read it. So
I read your motion and I looked at the portions that you were talking about.
Hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with a motion by Ms. Love that was the 4th time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory. But it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm asking you to disqualify because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you.
Nice.
As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Shart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to. And I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right.
Wow. Oh God, Love's not going to
Do y'all
get
want
up
to be
there.
heard from the state on this?
No.
Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court
All
would
right.
just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out.
Yes.
Thank you.
Thank you.
Appreciate it.
I wonder, is she going to call Hilton? I mean, that's dumb. Is that a dumb question I'm asking? But is she going to call the other prosecutor? Because she hasn't been there all day today. Is that because she wanted to keep her out? I don't know. Who are they going to call? Ghostbusters. Everyone coming in with the Ghostbusters. I set myself up for that one. Set myself up. Oh, she's on vacation. Sorry, I did not know that. Thank you. Let me see if anyone has posted the Sarah Boon hearing while I still cannot tell if it was recorded. I don't see anything. All right, if you haven't hit that like, hit that like. I don't see anyone has posted the latest Sarah Boon hearing. It definitely went on. I posted the notes from the docket. But I don't see that the hearing was covered unless there was a camera in there and they're just saving it to yeah. We were watching this morning. The dudes kept falling off the high bar. Like all of them kept falling off the high bar. Did anyone see the steeplechase? One dude got like pushed out of the way and he had to like go backwards and jump over the obstacle into the water, and he still almost qualified. It was wild. Guy was fast. Oh, I'm not live. I am now. All right. Well, if you could hit that like if you haven't already, that would be greatly appreciated. We're on a little break here until the state is going to present some witnesses for their case, which I don't even care about the state's questioning. I can't wait for the cross-examination on that. Not sure what time they're going till today. It's hot as balls in my house. I think we're at 76 degrees because my stupid central air died and I have like a weak-ass air conditioner. So that's fun. Movement in front of the camera. We should be back any second now, I think. So yeah, if you're coming in late, it's been hearings all day. No jury yet. I don't think they're back yet. I don't know when they come back. Going over the ex parte meetings that the judge Glanville had with the prosecution and witness Kenneth Copeland, little Woody. And the state's about to call some witnesses because the defense has called their witnesses. Position a couple of box fans in your windows facing out to help blow. You're saying open my windows, but I got the AC on, though. Then the AC is going to go out. Not that the AC is doing it. I really should have to buy another one probably, but I can't do that right now. So I do need to drive into the ocean. That would help. It's a good idea. By the way, I did see, for folks who don't know, I am not covering Karen Reed, but apparently there's a hearing on Friday, so I'm going to strongly guess, unless Bob is doing something else on Friday, that he will likely be covering that. So, hoping everyone in Florida is doing all right with this storm, Debbie. Oh no, C-Dub, that's terrible. I'm sorry to hear that. By the way, if you don't know this, I am on all social media. The Shaming of Jay on all of them. I'm on Instagram. I'm on TikTok. I'm on Facebook. I try to post to all of them. But if you want to give me a follow, if you're on any of those things, give me a follow. That was me opening up the gram. I'm closing in on 4K on the gram, which is kind of cool because Instagram is really hard to grow on an audience. I mean, Facebook's the hardest so far from my experience, but I'm almost at the 4K on the gram. We also have a Patreon. Ooh, I do have... Hey, Sherry, good to see you. I do have Babe Got Me for my birthday. One of those things you put around your neck that's like a fan thing, but that would be really loud. But I will put that on when I'm not streaming. Hey, Kim. Oh, nice. Thanks, Donna. That's word of mouth, folks. Tell your friends. Donna told her hairdresser. Tell your friends. If you're in any like true crime groups on Facebook or anywhere, tell them about the channel. You are our biggest advertisement. Being I don't know how else to advertise. Thanks, Annie. Annie just subscribed to the gram. Thank you, Annie. What are frog togs? Remind me in 20 minutes. I got to feed the friends. Well, they'll remind me in 20 minutes. By the way, again, thank you to Jersey Jen and to Renee S., who sent my friends treats off the wish list. Oh, also, I do have my Amazon. If you don't know, I have an Amazon link. And all that means is all you got to do on this link that I share here is just order from Amazon like you normally would. And I got a little commish. I got a little commission if you're interested in doing that. Little commish. There's Renee. I mean, I clearly think this case is going to go forward, and they're not going to dismiss it. But I mean, maybe they'll remove one of the prosecutors. Thank you, Jen D. Thank you. Also, I'm due to do another episode of my. I haven't been doing my thrifting channel. While we're waiting, though, hold on. Let me see something. I can show you some of my recent solds on my eBay because I've had some sales. They haven't been like the best sales, but they've been pretty good. What did I? Let me see. Orders, paid and shipped. Here's some of my recent sales on eBay. I have a channel where a YouTube channel where I talk about thrifting because I do that part time too. Here are some recent sales while we wait. Whoops. I sold. If you guys watched, one of my recent episodes, I got a bunch of little Fisher Price. These little guys, little people. I sold a lot of them for $25. All these guys are here. These pictures are terrible, but I sold them for $25. I sold these two VTech Disney things for $15. I sold a 3 Blood, Sweat, and Tears. There you go. Here you go, Travis. Here's 3 albums I sold. Blood, Sweat, and Tears lot of 3 for $20. I'm always worried when I ship albums because I'm worried that I'm gonna get a bad, because people with albums are very serious about, like, I try to take really good pictures of this stuff so people know what they're getting. So far, I have not gotten bad feedback on that, so that's good. I take pictures of them. That's how I try to, like, you could tell when they're really bad scratch. You could tell. I sold this. This was a good sale. $40 for this. This was the tin by itself. You don't have to sell Pokemon cards. All this was a tin I got for like $5. Empty tin. But the tins are collectible. So I sold this Pokemon tin for $40. That was a good sale. We're not live yet. All right. Another sale. Blaze and the Micro Machines. $20 for 2 of these things. Blaze and the Micro Machines. Or no, Blaze and the Monster Machines. Diecast. Certain diecast. Sold those for $20. Sold these Jack's miniature doll figures that were like, this was in like a bag that I found. These little dolls. I don't know what the hell they are. Should have saved it for the Olympics. Sold these for $20. Like I said, none of these are huge deals, but some of my recent sales. Kinder Joy Toys? No. Kinder Joy Toys. The nice thing about small toys, easy to ship. Easy. Records are a little bit, I have special boxes for the records, so I ship those. Oh, toys that come in British candy. Interesting. They're illegal in America. So you're telling me I can go buy an AK-47, but not a toy and a chocolate? What happened to like a 2-minute break? What's happening? What's going on here? By the way, folks, I've been posting. Have you guys seen these calls from Wade Wilson that have been released recently? From jail, Wade Wilson, that guy with the tattoos all over his face. These calls are wild. Nice one, Elizabeth L. Coming in hot. Your mom needed an extra 20 minutes. Yes, and there are truthers out there. There are people who think that Wade Wilson was innocent, if you can believe that. They are creepy as hell. He's so matter of fact, whether he's talking to his dad or his ex-girlfriend. The way he talks about killing these women is just, it's scary. It is scary. Oh, they're in Canada too. Is it Kinder or Kinder? I'm no great judge. He seemed like before all the tats that he was a decent looking dude. But now, of course, he's got fucking swastikas all over his face. Kender? Kender? Donna says Kinder. Oh, trial lover.
I'm gonna bunk with you, buddy. We're gonna be buddies. We're gonna be pals. We're gonna wrestle around.
Welcome, trial lover. Elizabeth L. is on fire. Kinder like limber like your mom. Wow, Elizabeth L. on fire today. Capri Sun's in the chat. Capri Sun's in the chat. For folks who don't know why we do Capri Suns, oh my God, this reminds me to tell you guys this story. Alex Murdoch, his favorite drink was a nice orange Capri Sun. When I learned that he wanted Capri Suns, which is okay as an adult, but orange, not okay, that's when I knew he was the killer. That and all the evidence. Anyway, speaking of Murdoch, I started reading the book. I started reading the book that I got an advance copy of, and Babe has never been more jealous of me in her entire life. She's like, "You're reading that? Why are you reading that?" I'm like, "I got a copy of it. I'm going to read it." She was like mad at me. She was mean mugging me because Babe loves to read and I don't. I hate reading. And she was like so mad at me. She was so mad at me for reading the book.
Witnesses for the state. Ready?
We're back.
Let's get that person.
We're back.
On the stand.
All
right.
I got the book because I'm an influencer, and the Random House Publishing reached out to me, said, "We'd like to send you an advance copy." And I said, "Duh, I'm a big-time influencer." That's how I got it. Seriously, they reached out to me. Oh, the book is from Valerie Berline. It's called At the Devil's Elbow or something like that. I forgot the name of it.
I remember one time when I was called as a witness in a case for some very ancillary matter, and we're so used to being the ones examining. We're not used to being the witness. And the direct finish, and I got up to leave, just like all of the lay witnesses who have no clue. And then I felt like an idiot. But
Judge telling more stories.
Maybe Mr. Abate won't do that. We'll see.
Oh, Mr. Abate. Valerie Berline's book, At the Devil's Elbow, I think. Let me see what it's called. It's not out yet.
Coming up to the witness stand.
You non-influencers can't get it until August 20th. I am an influencer. The Devil at His Elbow. The Devil at His Elbow. Alex Murdoch and the Fall of a Southern Dynasty by Valerie Berline. You poors can't get it yet. Me, influencer, has it already.
Thank you. Good afternoon, Chief Deputy Abadi. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the Chief Deputy of the Major Crimes Division.
All right. And February the...
Please slow down. ABBATE.
My man
And I
is
said
not
chief deputy of the major crimes.
This man's body language is screaming, I don't want to be here right now. This man does not want to be here right now.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John?
Guys, the devil at his elbow. All right, let me just clear this up. The devil at his elbow is a Cormac McCarthy quote, and what it is I don't know. Hold on, it's in the book. It's like the first thing. Oh, it's from Blood Meridian. You can find meanness in the least of creature. Wait, you can find meanness in the least of creatures, but when God made man, the devil was at his elbow, a creature that could do anything. Maybe you poor people can start reading books and become cultured so you can learn these things.
John Melnick regarding a person by the name of Kenneth Copeland.
Yeah, it was a conversation on the Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to. Yes.
All right.
Judge was on the call.
And
Judge
would you
Whitaker
tell
was
the
on the
court, what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think maybe 134. It was his possession of a firearm by a convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
Right. And did the state's proposed bond order have any reference to or any
Elizabeth, you know who had it on her high horse? Oh, you know, Elizabeth, I don't have to tell you.
conditions that are related to Mr. Copeland's witness, position as a witness, in this case, 22 SC 183572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffrey Williams.
All right. Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case.
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182134.
Thank you. Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom, and it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker, and the conditions that would be included in it.
Was there any part of that conversation that referenced?
The biggest battle today is between love and a microphone.
Mr. Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically. And the reference is that Mr. Melnick was all hot about the fact that I was on the call representing, as a representative, pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before that this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks as it related to you and the district attorney's office, and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, negotiate and agree upon bond conditions for. I think it's 22 SC 182, I think it's 134, and the charges were possession of a firearm by a convicted felon, and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, sorry, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess is the correct word, as it relates to Mr. Melnick's reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness in this case?
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
And showing what our market states is it too, I don't know if the court had already.
Here you go. Here's the bond order.
I guess the point they're trying to prove here is Melnick was like, don't fucking contact me about this case.
A copy of the filed bond order. Is that the bond order that you spoke with Mr. Melnick about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 23rd, excuse me, February 24th of 2023. This is this is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134.
Be right back. I gotta feed the friends.
So this would have been the product of that conversation.
Okay, thank you. All right, that's all that I have for this witness, Your Honor, for right now.
All right. Any questions by any of the defense attorneys for this witness? Nope. Ms. Weinstein, Mr. Matthews,
No, Your Honor.
Mr. Harvey, who I can't really see over there in the corner. Is he even there? Is Mr. Harvey over there? Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down. All right, call your next witness.
State calls Attorney Peter Herzog.
Okay. It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I'll have him sworn in.
All right, yes, please swear him.
Raise your right hand. Swear I firm testimony you tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat.
Thank
you. First and last name, of course.
Peter, Peter, Herzog, Hertzog. TZOG.
Good afternoon, Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
How long have you worked in the anti-corruption unit?
Since I started in the office, about a year. I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2023.
Yeah, I think it was March. I've been here about a year and a half.
Okay. Have you ever worked in any unit besides the anti-corruption unit?
I did a short stint where I screened cases and then I cover a court part for a complex, but I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Cole?
Yes, I believe so.
At any time during those conversations, did you ever, in any way, seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hilton?
No, not to my recollection. No.
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
No, absolutely not.
Is this the longest you and I have ever even talked?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think we've had much contact.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about A case that was in your unit?
Yes, ma'am.
Were you ever asked by anybody in the DA's office to have any communication with Mr. Jones regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Your Honor, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court reporter.
And I'm going to show you what has already been admitted as defendant Williams number 4, Your Honor. And I'm going to show you ask you to take a look at the bottom portion of defendant Williams number 4 and ask you if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Millick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were investigating, as part of anti-corruption, we were investigating.
Without getting into the details of any anti-corruption case at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here. I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was when you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because, if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Copeland?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did a thing. I wrote a check mark, and I'm gonna have to get that off the report.
Okay, probably have some white out. That would work. Is that okay with everybody if on states 4, Ms. Love White felt the check mark she inadvertently wrote on states 4, which is why I don't like to ever handle the evidence, because I'm constantly taking notes and then I end up writing on the evidence.
And it's defendant's Williams exhibit.
Is that okay? All right. Thank you.
With the court's permission, I'll do that after Mr. Sharp has had an opportunity.
Oh, we got some cross from Sharp.
Go ahead, Mr. Sharp.
Good afternoon.
Good afternoon.
So, from what I understand, March 2023, you are working for the DA's office in the anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
And he's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witnesses.
Sustained.
What kind of case was this?
Objection as to the.
Well, can we just leave that it's an anti-corruption type case?
Was, I ask, was Mr. Copeland the alleged victim?
No.
So he's a witness.
Well, it's
Your Honor.
Yes. Do we need a bench conference? Okay.
And we're live. What did I miss? Why did they? Oh, shots. Yeah. Hey, Jen. Oh, I'm glad you're tripping. Thanks for watching it.
The earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Sharp relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or.
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry we're having technical difficulties. Apparently you need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. But one of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, to then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams? Okay. Who else do we have? Mr. Stillwell, are you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it. So y'all can't even get it.
Why? What? I missed it. Why are they up right now? What are they? Allie always coming in with the info. There's a corruption case with Woody as a witness, and they can't blast the reason for the corruption case, so they're doing a sidebar to fill everyone in. Thank you, Allie.
Thanks a lot, man.
I'll take a Cabana Boy. Send him down, Donna. Actually, I think I have memberships to give. Hold on. I already gave 5 of them, but I get 10 a month. Let's see. Do I have more? If anyone, oh, they're back. Hold on. Let me see. Go to my channel. Go to here. Let me see. Go. Just heard myself. Let's go to show your support for Jay. I do have 5 more memberships. Here we go. Squaducial. Like I said, I always blow my load with these like on the first day of the month, but whatever. I only get 10. Who's going to get them?
Your life, bing bong.
Oh, and Ariel gets one. Your boy did it.
And do any of the defendants have any questions about it that they want to ask me?
Because I'm going to bunk with you, buddy.
Okay. And
We're
did
going to
you
be
talk to
buddies.
your
We're going to
client
be.
about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in March 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now,
Oh, Allie
at the
didn't
time
get
you
one?
sent this
Shit.
email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on.
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone that was. I wouldn't speak with someone that was represented by counsel.
Okay.
On any case or was recently represented by counsel.
Okay, so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation, in the
I
limited
understand.
scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
I have no further questions. Thank you.
Does anybody else have questions for Mr. Herzog? All right. No.
Any relation to Whitey Herzog?
For the court.
Sure.
Whitey Herzog.
I don't understand enough about it, and I understand that the ruling is maybe I shouldn't know about it. Would the court Mr. Williams has no objection, and if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal, or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but that's valid. Let's find that out. So you can ask that question.
Come on down, Steele.
You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Steele.
How are you?
Good, how are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Is this the question whether I feel comfortable?
Yeah. Do you understand Brady and its progeny, what it includes?
Yes.
Okay. And I didn't mean that to be insulting at all. Just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland, was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay. And I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay. All right. Thank you, Your Honor.
Okay. All right. Anybody else? Mr. Williams? Okay. Anybody? All right. Any redirect by the state? No, Your Honor. All right. Thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
I couldn't allow Mr. Atkins to go outside and check.
Sure. While we're waiting on finding that out, y'all were, well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting.
Objection! Extremely racist!
Nothing. Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of, since we're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date.
Okay. All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that. All right, what do we know, Mr. Atkins?
So Ms. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay.
Miss Potter?
Okay.
Tell her to get on her fucking broom. Tell her to get out of the Quidditch match. Is that what it is? Quidditch?
Tomorrow?
I can, yes, I can do that.
All right.
Tell her to get out of Snufflepuff.
Other thing that I was looking at was to I'm obtaining a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him, since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case, and there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the on June 10th, in terms of King and its progeny, and what the transcript reflects, and the court has heard testimony reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented? I understand the assertion in that regard to be that the prosecution has violated a bar rule, and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay. And Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I asked for the court's brief indulgence while I get the certificate of service and the date that he was served.
Okay.
Poor Harry Potter's wife, coming all the way from Humbledorf, not going to make it to the hearing. Now they don't even need her.
All right. I'm not even sure which one you're talking
Canceled
about.
her Quidditch match.
Sure, if it's relevant, I will
from
unseal
Dumbledore.
it. Can you let me know which one it is?
It was a certificate of service, and it was filed on. Okay, that's what we're getting today.
Okay. It's and that's in which case? This
22.
YSL case?
Yes.
Okay.
Who's this fucking guy?
So I actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think, in May of 2024.
Okay. Without
the exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May 31st
All right.
of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she going to be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does.
Open up a
I
fucking
don't even know if she's
wizard
available,
portal or
but
some
that's
shit.
an option as well.
Thank you, Judge. That would actually
Zoom from the
All right.
fucking
Would that be okay if I
castle.
don't know if everybody's familiar with Miss Potter, but I don't know if is she still with the DA's office?
She is. She's
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Meldick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony
Hogwarts.
by Zoom here in court?
Have her zooming in from Hogwarts. That's the name of the school, right? Hey, I know it is.
If anybody
Hogwarts.
has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
What are they talking about right now?
And as Ms. Love's doing that, Mr. Atkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Jail calls. Let's hear those.
Your Honor, I have not spoken with any defense counsel in relation to those jail calls.
Okay. Wasn't that your task?
Oh. Uh-oh.
Your Honor, I will speak with Mr. Shard.
Okay.
Uh-oh.
I can't remember who said they were going to do that, but
Wasn't
I
that
don't know.
your
Y'all
test?
had told me at the end of Friday before we had all of our more explosive motions put before the court that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe two items that you thought you could work out everything, and there were two items that were still kind of in dispute.
That may have been Ms. Hilton.
It might have been. I don't know.
Just to get him.
I was out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
No.
I mean, so what we
I
ended up
don't think
doing
so.
was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes?
To line up Ms. Potter?
To line up Ms. Potter, and to speak with another member of our office.
Okay, so we will take another break and be
Judge.
back whenever you let a deputy know that you're ready, okay? Which hopefully won't be more than 10 minutes. All right.
Oh, my God. All right. I'm off. JK, I don't know what to do for these 10 minutes. I don't think Sarah Boon's hearing was recorded, or it hasn't been released yet. Give us some deals. What do you mean give you some deals? Not after it went forward. The hearing went forward. I posted the notes. If you guys missed it, I can bring that up. While we wait. Damn it. It wasn't streamed, though. I just have the court minutes. Status comments. Status held. The court addressed several of the defendant's motions and set deadlines as it relates to exhibits and witness lists. The court will prepare specific order with all the deadline dates as what was stated on the record, including the cost for the JACS. The court provided the defendant in open court a copy of an email dated 7/24/24 from Gina M. Giovanni, Captain Security Operations, and a copy of today's order hearing. Court witnesses sworn and testified. Christian Lake with Jack's investigator, Billy Lane. Representative from Billy Lane, representative from Prison Break Investigation. Sergeant Donald Casey, representative from Orange County Jail. The court advised investigator Billy Lane, representative from Prison Break Investigations, to release the thumb drive to Sergeant Donald Casey, representative from the jail. Investigator Lane also released the 2 boxes of discovery back to the clerk in open court. Defendant requested that the 2 boxes of discovery be released back to the investigator. The court granted. So you're telling me this guy brought the fucking 2 boxes of discovery that Sarah Boon requested, and she's like, nah, take it back? She requested it be released back to the investigator. The clerk released the 2 boxes of discovery back to the investigator. The trial remains as previously set. The trial is set for, as you can see here, October 7th. Boon is on Court TV now?
The defendant's temporary motion for reservation of
Thank you,
costs
Jonathan.
investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire
Jonathan,
witnesses
MVP.
for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All 3 motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boon a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boon gets a copy of it. State, do you have any position with regard to those 3 motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for, or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Here we hear Sarah Boon.
Here we go.
Yes, here we go. She is wanting to add information there. We're going to hit that pause button. We're going to have more.
Oh, this is why I hate this shit. Are you kidding me?
Of her hearing right after the break.
Join Court TV.
Are they the only ones who had a camera in there who caught this hearing? Come on. Where are you at, Long Crime? And they're still on break after that. I'll be right back. I gotta let the friends outside.
On Grit Extra.
We'll be waiting for them.
Just gonna mute that so I don't get a copyright claim for whatever music that was. You live and you learn, folks. You live and you learn. What's up, Laura?
And the motions hearing for suitcase murder trial defendant Sarah Boon.
Before we get you back into court, let's bring in criminal defense attorneys Jack Rice, Josh Schiffer. All right, tell us what you think about so far the motion. I mean, I like the way the judge is handling it and talking about, hey, these are the amounts, this is where it's coming from, this is what I'm going to do. Josh.
Yeah, this case is, I just don't even know how it continues to go forward with the way that it is. I'm just sorry, my brain's spinning with something that I just thought about with how she's going to have constitutional challenges to some of these requests and whether there's going to be a fair trial at all here, given the reliance of the court on her as a pro se.
You know what, Jack? I mean, when she's talking about, you know, Chatty Cathy, she had something to say. She essentially said that she hadn't received her discovery, right? And again, the judge did the right thing. He says, when we find out what your witnesses are, et cetera, we'll start dealing with costs then. But then, to Josh's point, when you start thinking about the logistics of this, her deposing witnesses, figuring out what witnesses she wants to depose, what issues there are. I mean, it is mind-boggling to think that this thing's going to go forward and actually have a trial date and have a fair trial.
Yeah, I agree. I see all of us stumbling here. I mean, when these happen, when somebody fires their public defender, when they fire their private counsel, and they say they're going to go forward on their own, pro se, what usually you will see is this, is a judge will say, look, we're going to hold you to the standard of a lawyer. The thing is what I've seen this for 25 plus years, they never do. They never really can, because part of what they have to do, what judges have to do, is they also have to protect the constitutional rights of the process, the due process rights of a defendant. And so regularly, they're sort of feeding them information at the same time, which makes it even more complicated. So you're watching this and you're saying, you have to stand up for yourself. You need to understand rules of evidence, rules of criminal procedure, how the process works, the investigatory process, what you're going to do when you're making arguments. I've been training people for 25 years how to do this. This is somebody who's never maybe even seen a criminal trial before, and she's supposed to run this herself. This is just a hint of how difficult this will be.
And it's kind of wild because she's under oath. They swore her in before they even got started. So then you have statements she's making under oath, but only for preliminary matters. It's a wild day in court. On that note, let's get right back in for more of the hearing with Sarah Boon.
No, Your Honor, again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boon needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant.
Ms. Potter? So, Judge, my request is that
by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boon's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boon misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is incenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul v. State 152 Southern 3rd 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State 45 Southern 3rd 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to again Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision, so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's rights away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
I don't want to be pro se. I don't want to represent myself. You heard her say that. You still think the judge has given her sufficient opportunity with 7 appointed attorneys?
I think he's on solid ground for any kind of appeal.
Yeah.
I do.
I don't know if maybe he'll do a standby lawyer out of an abundance of caution. That's a decision he'll have to make.
I think he should.
Yeah, I think so too, but we'll see what happens. Thanks to Jack Rice and Josh Schiffer for joining us today.
Folks, stick around. Coming up, more from that hearing for Sarah Boon.
All right, I'm gonna go back. If anyone is watching Court TV, if you could let me know when they go back to the hearing, hopefully I can catch on to that. I'll keep it going.
That the court allow us, if I call her, to do it in the morning, and to also allow us to, because we've got the case that.
Hang on.
We're missing some defendants.
Sorry, they said we're ready. So I just kind of assumed we were ready. Hang on.
Oh, God.
Okay.
Oh, okay. 23. Yeah.
Mr. To allow. Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford Motor Company case that we provided today, and in making our final argument, and to allow us, if we decide the need to call ADA Potter. The main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the 3 names.
Oh, okay. So you may not need her after all, then that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not
sanction. Yeah, sure. You haven't had a chance to take a look at it, sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present. But if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that we keep copies, so I can get one of those too.
Service of. I think that I've got the certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and I'll let you look at it, but it looks like it actually is also attached as a, and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24.5.507 that gives him immunity, maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean.
Live, I'm Michael Ayala. We begin this evening with the suitcase murder trial. Defendant Sarah Boon is in court for the second time in a little more than a week since the judge ordered her to represent herself after going through 8 attorneys. Well, the judge is hearing several motions that she filed in her criminal case. Now, in one of the motions that she sent to the Judicial Administrative Commission, she asked for a standby counsel, saying she needs someone to help her prepare for her case. Now, in its response to that request, the commission deferred to the court ruling, saying the court entered an order on June 28, 2024, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel. Now, that issue came up in court during today's hearing, now along with extending the dates for Boon's upcoming trial. Take a listen.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boon representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boon, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right, so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boon, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boon hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boon would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boon. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
All right, let's bring in our guest for this hour, joining us to discuss.
Dude, what was with dude? Take off your jacket, sir. Stay a while. This guy is in court with his fucking raincoat on.
With a laptop at the jail. And then she...
Whoa, look at this bearded gentleman. Look at the beard on that guy.
And if so, we can make a copy of it and you can do.
Said it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think, then in the record.
Yes. Yes.
Your argument you wanted to make about that, or just
that, and I can reserve the rest of it for tomorrow. But just that he was served. Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify, or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
all right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then just maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That in the Donovan Thomas murder is what I mean.
Oh, that's the first one, yeah.
Okay. All right.
It's directly in the way that he did.
Okay. Okay. All right. But we need to make some progress into I am still considering and working through Mr. Sharp's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who's certainly authorized to talk about each and every case because they're all her cases ultimately. But, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
And Your Honor, we did get last night, speaking of things that we can deal with.
Yeah, just shows how consuming overall.
Here we go, do it. So now you're getting more true.
Yeah. We got last night from Mr. Sharp, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proffer of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us address those. So, and I believe that Mr. Sharp, he can again correct me if I'm wrong, said that he could go through that was from the August 2017 interview, a proffer from Mr. Zachary. There's an earlier one that I think he said he's going to go through and okay. He said he's going to go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And if that is the case, then the state would have a motion for the court similar to the one prior. With respect to Mr. Copeland.
You're gonna have to give me a hint as to what you mean by that.
So Your Honor, just now Your Honor referenced if Mr. Copeland chooses to do something different than what he chose to do last time, to testify, I'm assuming the court means plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some, I mean.
That's what I was
okay. All right, well, I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter or if that's just giving me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness, who the state thought was going to be testifying voluntarily, under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it. Because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now. Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse. I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony on the 10th, 11th, or part of the trial.
All right, which is why I need y'all to get together on it, and let's tackle that tomorrow, the nitty-gritty of it, okay? All right, so that means y'all have to do that tonight if you haven't already done it. All right, anything else before we break for the evening? One more thing. Other than the all right, so it's my understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Ms. Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Persefield, who forwarded it to you, or she'll forward it directly. So y'all should have that very shortly. All right, anything else before I bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's
Jesus, Sharp.
plan to bring the jurors back in on Wednesday? Is that still the plan?
I don't know, because we got things done today, but we didn't get any evidentiary, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning, regardless, this coming Friday morning. And I'm not going to, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.
A later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, that would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense to me.
That does make sense, and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea.
Yeah.
Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boon from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boon has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
Then we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality that is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boon, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail, and I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court.
All right, Boon's trial is scheduled to begin October 7th, and the judge actually extended the trial from 2 weeks to 3 weeks because she's representing herself. Let's bring back in our guest still to discuss, criminal defense attorney, former prosecutor.
And unmuted. All right, guys, I think I'm going to end it here. Obviously, if you want to catch the rest of the hearing, it's on Court TV in between 6,000 commercials and this guy from Guess Who. Charlotte nailed it with that. All right, guys. Thank you so much for being here. Thank you, mods, as always. Appreciate it. Gonna review. If there's not another trial, I'll see about covering that Young Thug hearing tomorrow. Just depending on if it's as hot as the seventh ring of hell in my house, I will determine that. So thank you all so much for being here. Thank you, mods. Thank you, everyone, for liking, sharing, subscribing. Thank you for all the super chats, Venmos, etc. Appreciate you very much. And I'll catch you on the next one. Thanks, everybody.
Thank you for joining us, J-Bo Nation. Please give all of yourselves an ovation. No, it won't be real long until next time. Oh, J-Bo Nation, there's no place we'd rather be. J-Bo Nation is the place to 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 be.